Here at the Four Boxes Diner, as part of my effort to make you the smartest person in the room when it comes to our right to keep and bear arms, I often talk about how individual precedents, cases, statements made by the enemy, and so on, all can be used to put together these individual facts, these individual cases, as little mini bricks. And all of these bricks, when you put them together, can build a brick wall around our right to keep and bear arms. I'm going to talk about one such brick today that the Second Amendment plaintiffs have found in an interesting place and an interesting name. The name, Free the Nipple. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the detailed account of how the anti-gunners intend to take away our rights. And if I were writing the First They Came for the Gun Owners today, I would include, of course, this effort by New Mexico's Governor Grisham, we're going to talk about in 1 second. All right, folks, breaking news. The Firearms Policy Coalition, the Second Amendment Foundation, and the New Mexico Shooting Sports Association have now commenced a fifth, by my count, lawsuit challenging Governor of New Mexico, Michelle Lujan Grisham's blatantly unconstitutional order to suspend a major component of the Bill of Rights, specifically the right to keep and bear arms found in the Second Amendment. Now, I'm going to go over some of the details of this lawsuit and their motion for a TRO. And what's interesting is the Second Amendment Foundation, the New Mexico Shooting Sports Association, and the Firearms Policy Coalition have filed this motion for a temporary restraining order to immediately enjoin this law, as have other plaintiffs in other cases. It should be enjoined. But what's interesting is that this legal brief, it relies upon a Court of Appeals case called Free the Nipples. Free the Nipple. It is a 10th Circuit Court of Appeals case involving the First Amendment and equal protection and the like. And the reason why I'm telling you about this is because we often talk on this channel about the importance of looking all around at history. The history of our country, the history of the courts, the history of other cases, the history of issues involving the Second Amendment, the issues involving things outside the context of the Second Amendment, where we, if we're smart enough and know enough, we can draw from to help us win. Here is a great example of that. The plaintiffs in this case against the governor are relying on a powerful 10th Circuit Court of Appeals case. Now, the reason why this is so important is the 10th Circuit Court of Appeals is the federal appellate court that oversees, you guessed it, New Mexico and Governor Grisham. So is there any important historical precedents that the Second Amendment community can rely upon to help win for our right to keep and bear arms? In addition, of course, to the Heller decision, the Bruin decision, and other Supreme Court precedents, the answer is yes, there is. You see, several years ago, the 10th Circuit Court of Appeals, in a case called Free the Nipple, found that a Fort Collins law that had banned public nudity, upper body nudity, I should say, of the chest and the breasts, was unconstitutional because it allowed men to go shirtless in Fort Collins, but it did not allow women to do the same. A lawsuit was brought by an organization and some women entitled Free the Nipple, and the district court judge says, indeed, you're right. This should be enjoined. So the federal district court judge in Colorado enjoined the Fort Collins law. Fort Collins immediately took an appeal to the 10th Circuit Court of Appeals, and indeed, in a decision entitled Free the Nipple, said that indeed the plaintiffs in that case were indeed entitled to an injunction because their rights not to be able to go bare-chested in public, and they were women, of course, was violative of their rights. And that should be immediately enjoined. Keep in mind that the state of New Mexico is deep blue politically. They're all Democrats all the time. In fact, the sheriff in the relevant county involving Albuquerque, who is actually a Democrat. Now, he's come out and said that this executive order by the governor basically barring the Second Amendment for the next 30 days, he's come out and said he won't enforce it because he thinks it violates the Constitution. And he's a Democrat. So the entire state is a Democrat, full of Democrats. The reason why this is significant is it's highly unlikely that you're going to get anything but a radical Democrat on the federal bench in New Mexico because the politicians out there would have to sign off on those judges before they're recommended to the president and nominated and so on and get through the Senate. So my guess is every judge in New Mexico is frankly left-leaning. Democratic supporting as a general matter. It doesn't mean they're not going to do their job, but their political bias is certainly going to be left-wing. Otherwise, they would not have gotten that job in New Mexico, is my best guess. And a lot of those are probably civil libertarian ACLU types. There's nothing wrong with that. That's probably where their bias is. So the reason why I bring this up is I suspect that a lot of those civil libertarian types and the ACLU types were probably sympathetic to the plaintiffs in Free the Nipple. Now, the reason why that's substantial is now you're relying on a precedent that the left-wing, probably left-wing judges in New Mexico are going to see, they're going to kind of agree with, and they're going to be like, yeah, how is this case involving the right to keep and bear arms, which is in the text of the Constitution? We have Supreme Court precedent of Heller and Bruin that's on point, especially Bruin, that says you have a right to keep and bear arms outside the home and carry guns for self-defense outside the home. This says you can't do it. That seems to be blatantly in violation of the Bruin precedent. And then they're going to look at this Free the Nipple case out of the 10th Circuit and they're going to be like, well, geez, by the principle a fortiori, meaning if it's true for the lesser, it must also be true for the greater. They're going to be like, if the right for women to be able to show off their bare chest is protected and they cannot be discriminated against vis-a-vis men who are allowed to do that, according to the 10th Circuit, it certainly seems to us here, this is how I'm thinking like a New Mexico federal district court judge, it seems to me that the case in support of the Second Amendment is stronger than the plaintiff's case in Free the Nipple, which is binding precedent on me because the 10th Circuit, again, oversees the federal district courts in New Mexico, and thus it's binding precedent. So I think this is a very smart strategic move by the Second Amendment plaintiffs to rely on this sort of civil libertarian-oriented 10th Circuit precedent to help win for the Second Amendment. As to what will happen, well, no one knows what judges are going to do, but I do think this is a way to appeal to sort of the civil libertarian left-wing tendencies that I suspect we're going to see in the judges there in New Mexico because of the fact that New Mexico is a deep blue state, Albuquerque is a deep blue city, and you're going to get deep blue judges, is my guess, as a general matter, because otherwise you would never get the job. Now, if you turn to the merits of the arguments made in support of the injunction, they're very powerful. To begin with, it's pretty clear that you have a textual basis for the right of the people to keep and bear arms. That's in the Second Amendment text, so you don't have to worry about that. And as you know, we've talked about this before, in Bruin, it makes clear that once something is implicated by the text of the Second Amendment, the burden shifts to the government to justify their modern-day version of gun control law. Certainly banning the ability to bear arms, which means to carry guns in public, certainly doing that triggers the text. So now the text is triggered, the burden shifts to the government to justify what they've done. Now, Governor Grisham here has made no attempt, zero attempt that I've been able to see, to justify what she's done with any kind of historical analog laws, and that's not a shock because they don't exist. In fact, remember, NYSERPA versus Bruin already did the work. So the Supreme Court says that once the text is implicated, the burden shifts to the government. The government has to show historical analogs. Obviously, that is what New York State and all those anti-gun amicus briefs did in NYSERPA versus Bruin, and the Supreme Court rejected all those analogs that tried to say that you did not have a right to carry guns outside the home under the Second Amendment. All that failed. So here you have a governor that is literally saying that because of public policy considerations, i.e. public safety, she's going to ignore the Second Amendment. The Supreme Court has already said that you cannot argue public policy, statistics, good and bad, tiers of scrutiny, interest balancing. The court's already said none of that is allowed. And we've talked about on this channel for almost 2 years that tiers of scrutiny is verboten. If you hear the phrase tiers of scrutiny or strict scrutiny or intermediate scrutiny or interest balancing, you run for the hills if you support the Second Amendment. I don't care who tells you this is a good idea. I don't care what their credentials are. I don't care if they're Second Amendment people or not. You run for the hills. This is 100% wrong, and you never, ever, ever make that mistake. You here on this channel understand that the way you do it is the text first and then the history. You never consider the balancing of guns, good and bad. That is not appropriate because the founding fathers already did any balancing associated with the gun issue, and they already said we have a right to keep and bear arms, and if someone doesn't like it, they can try to amend the Constitution, have at it, but that's not going to work because we have 27 states with permitless carry, and that number is growing. But beyond that, let's go back to arguments made by the Firearms Policy Coalition, the Second Amendment Foundation, and of course the New Mexico Shooting Sports Association, in addition to their reliance on Free the Nipple and their arguments about the text and the history, they point out unequivocally that Bruin actually is all you need to consult in this case. There is no historical analogs to even be considered. That's why, of course, the governor didn't even try, because she can't. She's already lost this issue completely. She appealed to this sort of statistical arguments and all this, which the Supreme Court has already said you cannot do under any circumstances involving the Second Amendment. So all of this is clearly blatantly unconstitutional, to the point where several anti-gun folks are even coming out saying that the governor went way too far here, and that it's simply not consistent with Nipple versus Bruin, and it should ultimately be enjoined. Now, a lot of you have asked me about, can this case be denied or stopped as being moot after 30 days? There is, just as a jog your memory, the notion of mootness is if something is moot, it's no longer a live controversy, and therefore it's no longer a case or controversy, and that denies federal court's jurisdiction once it's no longer a case or controversy. And if something's moot, it means it's moot, then there's no more case or controversy. So here, it is certainly the case that the Governor Grisham could issue another executive order in another month or 2 months. So I think this is something that could readily be replicated and occur back again. Obviously, it can't get resolved in the time. 30 days is not enough for any litigation to commence and end. So bottom line is, I don't think mootness will ultimately be a problem, because the reality is, I think it could be viewed as repetitive. Now, maybe at the end of the day, if this expires in 30 days and she admits that there's a mistake here, maybe it all goes away. But I'm not sure it will, and we'll see what the Second Amendment plaintiffs do. It'll be interesting. But in the meantime, I hope you learned something here today at the Four Boxes Diner. Don't forget to follow me on X or at Four Boxes Diner on Twitter there. And again, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.